Hello everyone, welcome to our IP Insights series, today on the topic of how the award of damages will be set before the UPC. I'm Johannes Heselberger. I'm here with my colleague Ronja Schregle. We are 2 of 22 patent litigators at Bardeli Pagenburg.
Our colleague Rebecca Jeschke recently explained reasons why damages proceedings before the UPC could be attractive. She mentioned the possibility to obtain interim damages, the request that the infringer shall lay open books, and last but not least, possibly some new ways to determine damages, which will be our topic today. How does the UPC determine damages?
Article 68 of the UPC agreement deals with the award of damages. Its third paragraph tells the UPC judges how to set the damages. Its wording is taken from the Enforcement Directive. It foresees 2 alternatives. Alternative A: all appropriate aspects shall be taken into account, including lost profits of the injured party and any unfair profits made by the infringer. Or, as an alternative, in appropriate cases, a lump sum based on elements such as at least the royalties which would have been due for a license.
Well, the first alternative does not seem to require any choice between lost profits on the one hand and infringer's profits on the other hand. Rather, it seems to take into account both to determine appropriate damages. To make use of this flexibility, the injured party would have to substantiate both infringer's profit, which it may like to do, but also its lost own profits, which may be more problematic because it would require this party to disclose its own costs.
The alternative, B, would be to set the damages as a lump sum, wherein the royalties which would have been due for a license form the lower limit. However, that alternative is only open in appropriate cases.
And the Enforcement Directive suggests that appropriate cases are cases for which it is difficult to determine the amount of the actual prejudice suffered.
But nothing in the law indicates that the appropriate damages in these cases shall be limited to a reasonable royalty. Maybe judges will apply a factor in order to achieve the overarching goals of compensating the injured party for damage suffered and balancing the unfair profits made by the infringer.
And in any case, it sounds different from the established German system, where the injured party can claim either lost own profits or the part of the infringer's profits achieved by the use of the patent, or a reasonable royalty based on its free choice. But the choice does have to be made, and the chosen alternative has to be fully substantiated.
Thank you. If you want to learn more about the UPC and the changes coming with it, visit our dedicated UPC website. You will find the link in the description.